welcome again. Un-Glew has produced a video of about 35 minutes in which he decries a short impromptu reply I had made to a presumed member of the freedom movement. He states that I have done no research and am talking nonsense. The nature of his video is somewhat rambling, but this response is not intended to be personally denigrating of Wayne, who I have met a couple of times, and whose tenacity in resisting unlawful government overreach is to be admired. He has suffered much abuse at the hands of so-called authorities, and it's a pity there aren't many more with his resolve to combat the many forms of criminal behaviour this encompasses. Nevertheless, his criticisms of my statements are gratuitous and need clarification and in some points rebuttal. Wayne's video unfortunately opens by omitting to establish the context of my remarks, a more complete version of which was completed shortly afterwards and posted on the Telegram channel MC1215 Knowledge Centre AU, as well as a few other web pages devoted to Magna Carta and specifically Article 61 of the same. So I was not opening by apologising for my views, but the implication intended was that of apologising for bursting someone's bubble of belief that the Australian Constitution is valid. In passing, contrary to Wayne's assumption, I have no association with any group called Terra Australis. I don't know where he gets that idea. The more complete version of the statement is shown here, in sections which can be read while pausing this video in order to keep this one from running too long. Wayne is one of the most knowledgeable people concerning that document, the Australian Constitution, in the nation. I've seen him quote chapter and verse from it with the skill and dexterity of any Bible preacher. However, the fact that one may know a great deal on a particular subject does not automatically mean anyone else talking about it is an ignoramus or prove that the literature on that subject is valid. Wayne refers to the Bible, the King James Version, as a valid source of law. But is that really so? The Bible, for example, promotes slavery in both testaments, and also that people should render unto Caesar that which is Caesar's and unto God that which is God's. Such sentiments at least imply an attitude of subservience to higher authorities rather than equality. However, the common law, which is known to everyone, is merely to treat each other with respect and others the way we ourselves want to be treated. So simple, it doesn't even need to be written down. It's apparent to any normally functioning human conscience. The straightforward position of Magna Carta is that all are equal before the law, and it's the monarch's responsibility as representative of the Crown to ensure that the rights and liberties of all subjects are equally protected and upheld. The justice system, which was specified as trial by jury, and the presumption of innocence, as in Article 39, was the mechanism whereby anyone, regardless of their position in society, was guarded against arbitrary detention or punishment without due process. Article 40 also specifies that there be no cost or delay in seeking or administering justice. Wayne purports to give me some lectures in history, accusing me of not having done any research, for example, on the history of the 17th century English monarchy, or the Bill of Rights and the Coronation Oath. However, I must point out that this is video number 60 in the series begun last year, under the heading Locked on Article 61 on YouTube, Rumble and Telegram, centering around the issue of Article 61 of Magna Carta. 2 full episodes, number 28 and 29, deal in detail with the treason of the Bill of Rights and contain detail of the succession of the English monarchy during the period just mentioned. Perhaps Wayne could do a bit of research himself. That would save me answering every one of his points here when I've already done so previously. There is a 6-part series included detailing how the Magna Carta Society in England reached the point of successfully motivating the Committee of Barons to petition Queen Elizabeth II regarding the invocation of Article 61. Wayne already knows all this because I have a document issued by him, which is shown here on last September the 22nd, 2022. In this document, Wayne asserts the seizing of the unlawful entities posing as Crown authority in Australia, specifically quoting as authority Article or Clause 61 of Magna Carta. However, that is where Wayne's views and mine diverge, and the main reason for that is his apparent failure to read all the way to the end of Article 61. I cover this aspect of the closing paragraphs of Article 61 under video numbers 3 and 4. It's important here to establish clear understanding of the nature of Magna Carta. It is a codified statement of the limitations placed upon the Crown in its role of governing. It is not the entire Constitution, nor do all sections of it concern constitutional matters. It is not the source of our rights. They come into existence with our birth and are not granted or legitimately taken away by any human agency, especially not a parliament or any form of legislature. Contained within Magna Carta 1215 are the Articles of Common Law, specifically Articles 39, 40 and 61, which form the Constitution. This Constitution represents a unilateral commitment that holds authority over the head of state and their delegates, encompassing all territories whose servants swear oaths that are subordinate to and limited by the monarch's coronation oath. The barons, who were King John's peers, were charged with holding the monarch, as the representative of the Crown, accountable for treason or oppression via Article 61, as it was correctly anticipated that John would try to negate the effect of the Charter's limitations on him as soon as he could. However, the basic constitutional issue is unaddressed by Wayne. That is the hierarchy of law and jurisdictions. Whenever there is a conflict of opinion about which law has precedence, the maxim is that the older has greater authority than the newer, unless the latter can be clearly shown to have improved the liberties of the subjects. Wayne himself uses this argument in papers where he discusses the relevant efficacy of the various state parliaments' constitutions. Mr. Glew's problem is that while he has laid claim to using Article 61 to seize the tiers of government in Australia, he has completely overlooked or failed to understand that article. While he became excited about seizing buildings, he ignored the rest of the article. So, for Wayne's information, Article 61 goes on to state that every subject is under a constitutional compulsion, which is in reality the inherent obligation to uphold the principles of universal morality in government, to transfer their allegiance away from the Crown, placing it instead to the Constitution. This they do by supporting the barons in their efforts to distrain and distress the Crown, until such time as redress is obtained, when they shall return to their normal relationship with it, which is that the people are in authority over their public servants. I haven't heard Wayne urging anyone to do this, which leaves the question, does Wayne think that only parts of Article 61 apply, since its invocation on March 23, 2001? And if so, which parts don't apply? And on what authority does he claim to specify those which don't apply? Even more importantly, and this point goes to the issue of why it's irrelevant to get into arguments about acts, statutes, bills of rights, etc., there are the closing two sentences of Article 61 which state, quote, "We will not seek to procure from anyone, either by our own efforts or those of a third party, anything by which any part of these concessions or liberties might be revoked or diminished. Should such a thing be procured, it shall be null and void, and we will at no time make use of it, either ourselves or through a third party, end quote. What is the meaning of these sentences? The we which is used to open them is of course the royal we, since King John is speaking of his office and all those who succeed him into it. They are bound in perpetuity, as stated earlier in Article 61, whose provisions are to stand for ever as our protection as Crown subjects. What is meant by a third party? Clearly, a party which is not involved in the original agreement between the monarch and the barons. Would a parliament which came into being and inserted itself into the legislative process qualify as a third party? Obviously it would. What about an Act of Parliament or an unsigned statement such as the Bill of Rights, which never received royal assent? Would they qualify as anything? Of course, those terms are extremely broad in interpretation. So what if an act or statute emanating from a parliament subsequent to Magna Carta purported to do, quote, anything by which any part of these concessions or liberties were revoked or diminished, end quote? Article 61 states most explicitly that such a thing, if procured, shall be null and void. It follows that the question must then be asked, do any of the acts, statutes, bills or edicts of any legislative body since Magna Carta in 1215, no matter what the size of the books it takes to document them, purport to revoke or diminish any of those concessions or liberties existing under that great charter? And the answer is yes. A great many of such things do just that, including, in many important respects, the acts enabling or otherwise, which brought into existence the Australian Constitution. Let's see why. It won't take long. Most of the clauses of Magna Carta relate to administrative matters of the various office bearers of that time, some of which have faded from use or evolved into differently named structures. There are only a few which relate to matters of constitutional law, most notable of which are Articles 39, 40 and 61. Article 24 is also applicable, which limits the interference of the Crown in judicial matters. That article was subject to meddling, wherein the original Latin was altered to permit such interference, but the original wording is still available and negates the Crown's ability to presume such jurisdiction. However, apart from those references, there is virtually no restriction on how the people referred to as Crown subjects may act, as long as they don't infringe the liberties of others. Most of the subjects obviously knew and observed that caveat better than did King John. Thus, Magna Carta was a restatement of the people's natural born right to govern themselves, and they were not to be interfered with by those claiming authority unless it could be proven before a jury of their peers that they had broken the common law. Now, under the Australian Constitution, are Crown subjects free to act as they choose, possessing full freedom of movement without hindrance or licence, free from arbitrary judgment by solitary figures such as judges and magistrates, assured of trial by jury in all matters, with such cases originating only from offended parties, not partisan government-employed Crown officers or constables asserting their claim to legal as opposed to lawful jurisdiction? And the answer to all of those questions is no, they are not. So have those acts, whatever fancy name the Parliament and confused people like Un-Glew may ascribe to them, purported to revoke or diminish any of the concessions and liberties existing under Magna Carta? The answer is obviously a resounding yes. One is fully justified in classing the various unlawful acts and mandates, etc., introduced during the COVID era, which extended to coercively insisting on unwanted medical procedures, as also purporting to revoke or diminish liberties existing under the English or British common law constitution. Those acts and statutes, etc., were enabled under the Australian Constitution, were they not? The upshot of all this is that since the invocation of Article 61, there is currently no Crown authority throughout the British Commonwealth, and any and all acts, statutes, or what have you that interfere in any way with the liberties protected under Magna Carta are unconditionally invalid, especially including the Australian Constitution. Wayne himself states that without Crown authority, there is no lawful authority. Yet he clearly wishes to accept the legislation which enabled the establishment of the Australian Constitution from the purview of Article 61, which is on his own admission constitutional law. That Australian Constitution purports to grant, under Section 71, the power to the Parliament to appoint courts and judges as they see fit to administer justice. It is obviously ludicrous from a lawful point of view to have the same body writing legislation as has the power to judge and enforce that legislation. That is the very definition of a dictatorship. One doesn't need to have a degree in constitutional law to see holes through which one could drive a bus in that scenario. The liberties proffered to Australians via their much-touted constitution are demonstrably far inferior to those we possess from birth, protected under Magna Carta, and would be rejected by anyone with an understanding of the principles involved. Thankfully, we have the protection of Article 61 to excuse us in rebutting any unlawful demands placed upon us by alleged Crown officials, no matter what authority they may cite. However, that protection is contingent on us following our moral obligation to stand for the truth and call out lawlessness. The mere existence of a document will not do the job for us. Thus, most of the arguments and confused statements made by Wayne in his rambling video don't even make it onto the battlefield. Such arguments about whether government departments and police forces or courts are corporations or not don't even get a Guernsey unless he first deals with the issue of the implications of Article 61 as outlined here. It's nonsense to argue on the one hand for the authority to dissent from government edicts on the grounds of constitutional impropriety as defined in Magna Carta, then to contradict oneself by referring to and waving about big red books of acts and statutes claiming validity for these, when they specifically fall foul of the very constitutional law one is espousing. My final point, illustrating the ridiculous nature of Wayne's allegations, goes to his accusation that I'm committing treason myself by speaking out against a government and legislation which he himself declares illegitimate. I'm standing as compelled by my moral faculties under the original oldest constitution that has jurisdiction over the entire Commonwealth, including Australia, and I suggest, Wayne, that you do the same. That said, go well, old warrior. Thank you for watching.